Why are we here? Cross-border litigation after Brexit. Tom, as you will have heard him just say, was a civil servant, so is entirely responsible for Brexit and what happens thereafter, personally and individually. But Tom worked in the Brexit department, if I can paraphrase it in that way. Yeah. So did work on Brexit. So he has some insight into what happened, why it happened, how it happened, and politics. This has given rise to some disagreements that I have with Tom, because I come at it from a much more kind of common law perspective of things. So what we think is going to happen in the future is diametrically opposed, I think, but we'll come to that in a little bit. We're going to talk about what's happened, why it's happened, the transition provisions, what we think is likely to happen in the future. And we've had a lot of questions in the run-up to the webinar on what we think is likely to happen with the transition proceedings, by which I mean those proceedings which were issued in the transition phase, so sort of towards the back end, particularly of last year. Some of them issued but not served, some of them issued and served, some of them issued but issues have arisen as a result of problems with service, serving outside the jurisdiction, can you serve inside the jurisdiction, who do you serve, how do you serve them? So those are largely the questions that we've been asked prior to the webinar. If you've been to one of the Chancery Lane webinars before, you know that we really encourage questions throughout. If you want to ask a question, then please do it on the Q&A. So you'll see some buttons, probably I think at the bottom of your screen, there's a selection of buttons, one of which is a Q&A button, the other of which is a chat button. We do tend to get quite a lot of chatter as the webinars progress, which is something that we'll keep an eye on. If you ask us a question though on the chat function, we might miss it because we'll be so busy gossiping about, you know, ancient history and who did what to whom in the European run up to Brexit and beyond. So if you ask us on the Q&A, then we know that we've picked up your question. The session is being recorded and it will be available on YouTube, got a YouTube channel after this. So if you want to ask your question anonymously, that's absolutely fine. That means that you won't go in the recording. If you do ask a question anonymously, it does mean that if we don't get it covered today, we won't be able to get back to you, obviously, and answer it. But you can, of course, then ask us personally, because our email addresses will be on a slide at the end. So either attach your name or not to the questions as you like, but please feel free to ask questions as we go through. We may answer them as we go through if we get time and if it seems appropriate to do it without stopping. Alternatively, wait to the end and we'll answer them at the end. But as and when anything occurs to you, there is no such thing as a stupid question, which we say every time. And quite often we'll get a discussion going about a question because actually, as we'll see during the course of this webinar, there are no right answers when it comes to what we think is going to happen after Brexit. And that's an overarching thing. I just wanted to make a point before we start that although Tom and I profess to have some kind of expertise in this area, your guess is as good as ours, actually, because by the very nature of this, these are points that have not been tested before. And they're points that I anticipate are going to be tested over the next couple of years, particularly jurisdiction points and service points. And so when we're telling you what we think is going to happen, it's really a best guess based on experience of other areas, but not on this area. Okay, we've already had a question, which is great. In relation to service outside, the service regulations, the HAGUE Convention. We are going to cover that. If I don't cover one of your questions, then remind me at the end that I've not covered it or we've not covered it. But without more ado, Tom is going to speak to you about what's happened before. I'm going to speak to you about what I think is going to happen later. Tom, obviously, if he disagrees with what I say, and I know he does on Legano, then he will jump in and he will tell me that I'm getting it all completely wrong, as no doubt will other participants. We've got quite a good spread of people here today. We've got some people who know a lot more about this than I do. Some people who've been involved in the Legano negotiations, for example, and others who've been involved with service and other policy decisions. So we've got, if we can't answer your question, it may be that another participant will be able to if it's policy, something like that. Another question, do we know of any upcoming amendments to the CPR's Part 6? Yeah, there actually has been an amendment to CPR Part 6, which is not yet on the website. So you have to go quite a long way to find it. I think I'm right in saying, Tom, that it's not yet on justice.gov.uk, but it can be found elsewhere.
It is now, I checked this morning, it has now found its way into the white book on Westlaw, but it's not still on justice.gov.uk in the kind of non-commentary parts. It is still the old rules in part 6.
Okay,
so,
well, the answer is, yeah, the answer is there has been an amendment, but I think we have learned that if we want to look at amendments, we don't look at the justice.gov.uk website, because the government is the last, either the last people to know what they're doing or the last people to tell us what they're doing. But Tom will deal with that as we go through, because that is one of the questions that we've been asked repeatedly, really. So where are we? Tom, over to you.
Thank you, Sarah. Okay, so I hope, first of all, everyone can see me and hear me okay. You obviously won't be able to tell me if you can't. I'm just going to assume you can. Picking up on what Sarah was saying, I'm Tom, and I was a civil servant. I did work, amongst other places, in the Brexit department. I was a policy advisor on EU exit. I had the pleasure of working for both David Davis and Dom Raab, though I'd left before Steve Barclay, the third Brexit secretary, joined in. I sat, when I was there, in what was known as the Negotiations Coordination Unit, so had plenty of insight into what was going on in the room in Brussels. And in fact, I was there for a couple of times for negotiations with the non-EU EEA states, the EFTA states, for some negotiations while I was there. The bit of my policy area was quite broad-reaching. It was the withdrawal agreement, separation issues, and miscellaneous Article 50 matters. And that last bit was a bit of dog's body catch-all to deal with things like Article 50 extension, Article 50 revocability, i.e. the Whiteman judicial review, if people are aware of that one. And then tangentially second referendum policy, which was very simple for me. At the time, the policy was, we just weren't having one. So it's really withdrawal and separation, which brings me to the starting point of today's talk. It sounds a little bit like a pair of anxiety disorders, but hopefully during the course of today, Sarah and I can help to quell some of the anxiety litigators might be feeling about all of this civil justice stuff. Hopefully will not increase that anxiety. So, as we all know, at 11 p.m. on the 31st of December, the transition period came to an end. It was a coup de grace that it was 11 p.m. and it was not midnight on the 1st of January, as it were, because we had to do it all on European time. So at that point, at 11 p.m. on the 31st, we moved from what was a transitory legal order, the one that's provided by Part 4 of the withdrawal agreement, to a new, and I put in brackets here, sovereign legal order governed as we are now, in some ways, by the Trade and Cooperation Agreement, which has been signed between the UK and the EU. But to be very clear, this document contains 0 provisions on civil justice cooperation. If you want a history of why it doesn't, I can probably go through all that at another time, but it would take a long time. So I can help anyone out with that at a different time or in my memoirs, but suffice to say, at this point, it's because of what were the UK and EU negotiating red lines. The UK had a line that said, we don't want anything to do with the CJEU after Brexit, and the EU had a red line which said, we must keep the single market uncherry-picked, if that's a verb. You can't cherry-pick bits and bobs of the single market, so you can't cross over that line. So in the end, there's some stuff on criminal justice cooperation and there's some stuff on family law cooperation. In the field of civil and commercial judicial cooperation, there is nothing. That did seem to come as a surprise to some people, but the writing was on the wall from as far back as in late 2018, when that aspiration was dropped from what was then the political declaration on the future relationship. So when we got that TCA, the Trade and Cooperation Agreement, in mid-December, some people in the goods sectors were exhaling sighs of relief, possibly only partial sighs because of all the bits and bobs we have on rules of origin, etc. Those of us working in the field of cross-border litigation were dealt the dreaded no-deal card. We got what was being termed Australian option, otherwise known as not very much at all. And we're left now with piecemeal bits and bobs which is now up to us to try and put back together to form some kind of regime for civil justice cooperation. So, and this is the next slide. When I'm talking about the EU regime for civil justice cooperation, what I'm mostly talking about is the latest iteration of the Brussels Convention, i.e. the recast Brussels regulation, that's 1215/2002, and the two regulations which are the inheritors of the Rome Convention, Rome 1, 593/2008, and Rome 2, 864/2007, the first on contracts and the second on torts. Now, these are not gone yet, as most of us are painfully aware from not actually caring too much that Christmas was cancelled last year because we were all beavering away at case preparation for issuing of all these cases before the end of the transition period. So as a brief recap, and this is over the page, as it were, over the slide, Articles 66 and 67 of the withdrawal agreement are the saving provisions, the winding down provisions for civil justice cooperation between the UK and the EU after Brexit. They specify in respect of the Brussels recast regulation that it will apply to legal proceedings instituted, and I make a note of that word, instituted before the end of the transition period, and in respect of related proceedings or actions. And Article 66 provides in respect to the Rome regulations that they will apply to contracts concluded before or events giving rise to damage before the end of the transition period. So I pause for a minute on the word instituted, and the question we've had a fair bit over the past couple of weeks is what counts as being instituted. If my claim, for instance, was issued before the end of December, but it wasn't served in that time, has it been instituted? And even further than that, if I got my papers to court on time, but there was a delay in the court issuing them, was that instituted? Well, to answer that question, we've effectively got to cover off 3 points of a triangle. The starting point, and this is over the slide, is that Article 67 of the withdrawal agreement refers to concepts and provisions of EU law. So in order to interpret these concepts and provisions of EU law and the word instituted in them, we need to know how to deal with EU law in the withdrawal agreement. Now, Article 4, which was the controversial article, which was breached by the Trade Act and led my old boss to resignation, says that where union law is referred to in the withdrawal agreement, it needs to be interpreted in line with the case law of the CJEU brackets as it was at the end of transition, a snapshot, as it were, of the case law of the CJEU before the end of transition. So in order to find out what the word instituted means, we need to go to the case law of the CJEU. Well, the point about institution of the claim is the same point as a court being first seized of the claim under the Brussels regime, which was handled in the case that I put out in the slide here of the case of Siegfried Zelger and Sebastiano Salinitri. And this was, in this case, it was said to be a question which was to be determined in accordance with national law. So effectively, we interpret the word instituted in accordance with EU law, and EU law says we interpret it in accordance with national law. So the UK effectively gets to decide what counts as instituted. And happily enough for all of us, the government have actually dealt with this problem and spelt it out in terms in regulations amending the Civil Jurisdiction and Judgements Act. And they have said in domestic UK law, i.e. the law we're interested in, a court is seized of proceedings when the document instituting the proceedings or an equivalent document is lodged with the court, provided that the applicant has not subsequently failed to take the steps required to have service effected on the respondent. And that sort of marries with paragraph 5.1 of the practice direction, which tells us that proceedings are brought for the purposes of the Limitation Act and any other relevant statute when the claim form as issued was received by the court. And I think that's enough there. It's not perhaps everything we could have wanted, but I think that is enough there to tell us that the answer to the question is that if a claim form is lodged with the court, even if it's not been issued before the 31st of December, and that claim is one which would have been covered by the Brussels recast regulation, then the court will have jurisdiction over it, even if it's not issued it before December the 31st, and even if it's not obviously been served. That is my view of the situation. But, and this is a but, and this goes to one of the questions that we were asked just before the start of the webinar. If you've got one of these cases where the claim was lodged or issued before December the 31st, but it hasn't yet been served, you're now going to have to wrestle with what are the new rules on service. Now, as Sarah mentioned, Rule 633 of the CPR has been amended to cut out all references to the Judgements regulation, i.e. Brussels recast, to the Legano Convention. Reference to the HAGUE Convention remain, and I'll talk more about that in a bit. But as we've said, this rule is not yet updated on the justice.gov.uk website, though it is, at least in my copy of the Westlaw electronic copy of the White Book. What the rule now states, by deleting its references, as it were, to the Judgements regulation and to Lugano, it now states that unless you come under one of the new consumer contract or employment contract provisions, and I'll deal with those again in a little minute, or if you come under the newly amended Rule 6.33, paragraph 3, which I think is going to be the crucial one, you are going to need the court's permission to serve on a party outside of the jurisdiction. So looking at the new Rule 633 sub 3, which is the key one here, I'm just pulling it up so I can read it exactly. It says, the claimant may serve the claim form on a defendant out of the United Kingdom where each claim made against the defendant to be served and included in the claim form is a claim which the court has power to determine other than under the 2005 HAGUE Convention, notwithstanding that the person is outside the jurisdiction or the facts giving rise to the claim did not occur within the jurisdiction. So what that effectively says is that if the court has power to determine the case, and it's not a case under the 2005 HAGUE Convention, then you may serve the claim out of the jurisdiction. Now, does the court have power to determine the case? Well, yes, it does have power to determine the case if it's one of these cases that you've got in before the end of the transition period, because the court has power to determine the case by virtue of the winding down provisions which give a long tail, as it were, to the application of Brussels recast in the UK for any proceedings which were instituted before the end of the transition period. So the court will have power to determine the case, and therefore, on my reading of the new Rule 633.3, and with the help of Andrew and some other members of Chambers this morning, I think the position is that you can use 633.3 to say, well, the court's got power to determine it, so we can serve it outside the jurisdiction without the court's permission. It's worth reading the commentary, I think, in the White Book on this particular part of the rule, which is for those with the White Book at 633.4. It says that it's effectively, the rule picks up from the old system, of the old RSC orders system, which previously referred to a claim by virtue of any other enactment the court had power to determine. I.e., it was an enactment which gave the court power. And although the new rule 633.3 doesn't use that same phrase under any other enactment, there is some case law set out in the commentary in the White Book, which says that it was likely that those words were meant to continue to apply, as it were. And that's what that means is that we really want it to be an enactment which enables us to serve outside of the jurisdiction, which gives the court power to determine the case. And I think, again, I think we're going to get over that line, because it is, of course, the various enactments which pull the EU regime into domestic law, which do enable which will enable the courts, as it were, to have jurisdiction over the claim, and therefore will give those courts power to determine the claim. So that's the rather sort of complicated new 633.3, and that's a little exploration of what's going on there. But in simple terms, I think the answer is, if the claim is lodged or issued before December the 31st, but needs to be served after that deadline, you're not going to need the court's permission to serve it, because the court has power to determine it under an enactment, as it were.
Tom, can I interrupt you there just for a moment?
Go on.
We've had a couple of raised hands. Now, I don't know whether that's raised hands because people have done it by accident, which does happen sometimes, or whether there may be some questions on this particular issue, because I know that you've answered it quite comprehensively, but we have had quite a lot of questions about this. So let's just take a moment, so that if you've got any questions, then just type them on the Q&A in relation to this issue, because I know it's something that's been exercising people quite a lot, because people have either issued prior to 31st of December, but it's not actually been issued by the court, lodged rather, or they've issued but not yet served. But I think that is probably covers off most eventualities, that if you've lodged, you're okay, and if you've issued, you're okay, and if you issued and served, obviously you're okay. But it's fine, I think, isn't it, Tom, from what you say, if it's just been lodged with the courts prior to the 31st, because that's then deemed issued, and you then serve after, pursuant to the amended CPR. Is that right?
Yes, that's my understanding of what the amendment to the CJJA does. It effectively spells out in terms that a claim is instituted when the documents are lodged with the court.
Yeah. There's a question on that, which is in relation to the N510 forms, which is the tick box form where you say the court's got power to determine the case because of it being heard under recast process, whatever it may be. So do you need to amend those forms before service to refer to the amended CPR rule 633, rather than the previous provisions you used to refer to? Now, actually, the form's not been amended, so I don't think you can amend to refer to CPR rule 633, as far as I'm aware. And actually, that was something that arose in property disputes in a different context earlier this year, where you had a cause of action, but the form that you needed to kick it off didn't actually contain a tick box in relation to that particular amended cause of action. But what would you advise, Tom, in relation to where there's been issue before the end of the year, they're yet to serve, and they're now serving under the new provisions rather than the old ones, because you would have ticked the relevant old rule under the old form. Now you're serving under a different provision, but there isn't a tick box in relation to that.
Well, there will be, presumably, I have not looked at the form in a while, but there will be presumably a tick box against the old 633.3. The old 633.3, for anyone who doesn't remember, said basically exactly what it says before, that where a court has power to determine the case, except under, and then it listed the Judgements regulation, i.e. Brussels recast, the Lugano Convention and the Hague Convention. But of course, references to the Judgements regulation and Lugano have been deleted from that. So now it's the case, it's ones which the court has power to determine other than under just the Hague. So I imagine the tick box is still there. Maybe I'd say tick that box because that is the right box, but just manually strike through the reference to the Judgements regulation and the reference to the Lugano Convention in that old rule. It's just a suggestion. I'm sure, as Sarah said at the beginning, there's no right answer for what you should do. But my view is that the rule applies as of January the 1st. So if you've not served before January the 1st, you need to serve in accordance with whatever the rules are at the time. And I've had, cases in the past where people have got all shirty about using, when the statement of truth was changed, for instance, to add the longer bit. But obviously on the gov.uk website, all of the old forms that you used, all of the old claim forms still used the old statement of truth. And then you had people, defendants kicking up a fuss about the wrong statement of truth being used because the wrong form had been used. I think it's better to just manually amend it if the government can't get around to sorting out their pro forma sometime. That's my view anyway. Shall I move on, do we think?
Hang on just one second, Tom. We've just got one question it's still on service, so it's still kind of on point. So on the Q&A, does 633.3 affect Rule 6.7 on service to European lawyers? Recognition of legal qualifications in the trade agreement, does this have an effect? We were looking at this morning, I think, on service on European lawyers.
It's a slightly different question, but there is a saving provision in the CPR amending regulations for service on European lawyers. I think it's Regulation 18, that's just off the top of my head, in the 2019 CPR amendment regulations, which are about where a defendant's given an address of a solicitor in an EEA state outside the United Kingdom, you can still serve on that address. I don't know if that's exactly the same question as Mark is asking here. I don't think Rule 633.3 specifically affects Rule 6.7 on service to European lawyers. But there is a saving provision with respect to European lawyers in amendments to Part 6 in general, which is, as I say, you can look it up at Regulation 18 of the CPR Amendment Regulations 2019. And that might go somewhere. I'm just looking to see through that in those regulations now, what happens to Rule 6.7 in general. So the amendments to Rule 6.7 are in the heading omit European lawyer and omit in any other EEA state. And in paragraph 2, omit or EEA state other than the United Kingdom and omit subparagraphs B and C, and omit paragraph 3 and the first set of words in parentheses following it. So I think that looks to me like they've taken a rather large knife to Rule 6.7. And what I would suggest is have a look on one of the copies of the White Book which has been updated, i.e. the Westlaw copy on the Westlaw copy, and see what remains, as it were, of the 6.7. And if you've got nothing of value there, then check the saving provisions in Regulation 18 of the CPR Amendment Regulations, which don't specifically amend a part of the CPR, but just generally help us understand what's going on in the new order of things.
Okay, another question, Tom, on, I mean, obviously, I think we could do a webinar on service alone, actually.
Yeah.
But under the EU Rights Against Insurers Act, if the driver insured name is not known, claimants could issue against the address of the European defendant insurer. Okay, what is the situation now in terms of issue on European defendants?
Well, I think we're going to deal with issuing on European defendant insurers, or rather serving on them in just a minute.
We are.
Think.
Sorry, I'll stop getting in the way, Tom, and shut up.
Sorry. Okay. So shall I move on from here? As Sarah says, we could get admired for quite a while on service, but I think. Just on the last bit on the previous slide. Sorry, is about. If the party's already nominated solicitors in the UK before the end of the transition period, then you will be able to serve on them. What you won't be able to do is serve on UK handling agents. And I think we had a question about this in advance of the webinar. The ability to serve on UK handling agents existed by virtue of the various motor insurance directives and the rights which were confirmed in the case of Spedition Welter, if that's good enough German. But this, the right itself arises effectively out of a policy of international cooperation, which has now ceased to exist. And it does require, it's one of those bits that does require reciprocity between the UK and the EU. And in this new order of things, we don't have that reciprocity. And so, sure enough, the motor vehicles compulsory insurance regulations have been amended to get rid of the bit which makes reference to claims representatives and which allows claimants effectively to do this. So the UK handling agents bit has gone, but you can, of course, still, if they're nominated solicitors prior to the end of the transition period, then you can still serve on those. So those are the bits for jurisdiction covered by the withdrawal agreement. What about enforcement? Well, this is also Article 67 of the withdrawal agreement, and it's the second paragraph, and it says that Brussels recast provisions on enforcement shall apply to the recognition and enforcement of judgments given in legal proceedings instituted before the end of the transition period, as well as to authentic instruments formally drawn up or registered at court, or court settlements concluded before the end of the transition period. So the first part is the interesting part there, because it doesn't say any judgment that you've got before the end of the transition period you can enforce under the old EU rules. It says any judgment that you get in a case which has been started before the end of the transition period, you will eventually, when you get judgment for it, be able to enforce it under the old rules for enforcement, reciprocally, as it were, between the UK and the EU. So UK judgments in EU courts, EU judgments in UK courts. So we can see quite easily how that's going to give us quite a long tail of bits and bobs of judgment enforcement. We all know how long some pieces of litigation can take. So if a case was started on the 31st of December of last year, it could potentially be years before, you know, we get to a final judgment of that, and then we have to start enforcement proceedings, and they will still be done under the old Brussels regime. So that's an interesting one that's got quite a long tail. And in some member states, if we're thinking about foreign judgments being enforced in the UK, I know we're slow in the UK in some of our civil litigation, but some places are even slower, if you can believe it. And so judgments from over the channel could come here for enforcement years down the line, and we would still apply the Brussels recast provisions to the enforcement of those judgments at that time, whenever it is, however many years we're talking about. Next bit of saving of the withdrawal agreement is, of course, the applicable law stuff and Rome 1 and 2. Now, actually, I'm not really going to talk about Article 66 of the withdrawal agreement and how it effectively saves Rome 1 for contracts concluded before end of transition and saves Rome 2 for torts before the end of transition, because we're going to keep them. We're keeping them in the UK. And Rome 1 and 2, as they existed on the 31st of December, have been incorporated as part of the so-called snapshot of EU law, which was taken by virtue of the EU Withdrawal Act. And the deficiencies have been corrected by some catchily named regulations known as the Law Applicable to Contractual Obligations and Non-Contractual Obligations Amendment, etc., EU Exit Regulations 2019. But effectively, they just, you know, fiddle around with what the definition of a member state is, given that we don't need those definitions anymore. But Rome 1 and 2, as they existed, are in domestic law. And the reason for that, you might say, well, why has that happened? And it's really because it doesn't require that element of reciprocity. It's not really a two-way conversation, what law a country's courts apply. It's a matter for that jurisdiction. It doesn't really matter whether the other side apply your laws if you in equivalent cases, if you apply their laws. You don't need that reciprocity. It's nice to have it, of course. And in fact, the good news is that we will still have it, because Rome 1 and Rome 2 apply to or when it comes to determining applicable law, that applicable law can be of third countries, i.e. non-EU member states, which we now are. So the EU courts will continue to apply English law for cases where that is the applicable law, just as we will continue to apply the various bits of Spanish law, French law, Romanian law, whatever it is, in our courts if the various provisions of the Rome regulations bite for those causes, for those cases. So that's a bit of good news. The other thing to point out while dealing with this new order for applicable law, again, it relates to this question that we've just had and questions we've been asked about in advance, i.e. what are my direct rights of action against insurers, particularly in RTA claims? So if we start answering that question entirely domestically, even though the direct right of action against an insurer only exists because of the EU motor insurance directives, that's not per se an arrangement which requires this reciprocity that I'm talking about. And so the implementing law in the UK has not changed for domestic RTAs, nor are there any plans that I'm aware of, and people may correct me if I'm wrong, to make those changes. So the EC Rights Against Insurance Regulations 2002, which give right to this direct right in certain circumstances, continue to apply. And those circumstances are, of course, for vehicles normally based in the UK and for RTAs in the UK. So the regulations have been slightly amended, of course, to do this deficiency corrections, to change the definition of what constitutes an entitled party. But the main point that the accident must have occurred in the UK and the offending vehicle must normally be based in the UK remains. So they are as is. So that's for domestic. So that's the first bit. So that's a bit of good news. In relation to accidents occurring in England and Wales, but involving foreign vehicles and insurers, you're probably still going to be okay, because Article 18 of Rome 2 states that if the law of the insurance contract allows a direct claim against the insurer, then you are allowed to make a direct claim against the insurer. So if you're a claimant in a UK RTA involving a Spanish insured driver, for instance, because Spanish law allows a direct right against the insurer, you can use the Rome regulation to, as it applies in UK domestic law, to directly bring an action against that insurance company. You will still, however, need to get over the line on the separate issue of jurisdiction, which will be under the common law, which Sarah will talk about in just a minute when I finally shut up. But presumably, you're not going to have too much difficulty because your RTA is going to be in, as it were, in the UK. So you shouldn't really have an issue with jurisdiction. But the point is that it's only via the applicable law provisions that you can get that direct right of action against the insurer, because the insurance contract is a Spanish insurance contract, if that makes sense. So very briefly now, just covering off a couple of final points before I stop. Moving on from the applicable law, what else are we left with picking through the ashes? Well, we do have the Hague Convention 2005 on choice of courts. Now, despite it being a 2005 convention, it didn't actually come into force until 2015. And it's one of these odd agreements where the EU was party on behalf of its member states, rather than the UK being a party to the convention in its own right, which means we've ended up in one of these slightly unusual legal situations, first of all, during the transition period, where the agreement continued to apply in a kind of emperor's new clothes way. There wasn't much of a legal basis. Everyone just said, we'll just imagine that everyone is still party to this agreement. We'll just imagine, sorry, that the UK is still party to the agreement and still treat them as if they were, when legally speaking, they're not actually a party to it, because we've left the EU and we're only a member by virtue of our EU membership. It's quite a sort of sleight of hand trick that the negotiating teams got to on this and various other bits of international agreements, including, you know, the various trade agreements with Japan and South Korea, etc. I can talk about those at another time. But anyway, now we've acceded to the Hague Convention because of this slightly odd system where we were only a member by virtue of our EU membership, there's a disparity of views on both sides about when exactly the Hague Convention on choice of courts applied to the UK. And now we, the UK, say the convention applies to contracts with choice of courts clauses in favour of the UK concluded before the 1st of January, i.e. all the way back to 2015. The UK's membership of the convention applies retrospectively. The UK says, no, that's wrong. It's only going to apply from the 1st of January onwards. And so contracts concluded before with their choice of court agreements are not going to be captured. Now, there's bound to be some litigation in this space, and so I would simply say, look out for it, watch this space, see what happens. For the present audience, the Hague Convention might be of limited value, as it's mostly dealing with contracts. Well, it's entirely dealing with contracts and not torts, and it doesn't cover personal injury. And when it comes to the contracts that it deals with, it's not covering consumer contracts. It's really B2B contracts and not B2C contracts. And those contracts anyway are not likely to have very many of these choice of court clauses in them. So that's the Hague Convention in 2005. The other sort of little bit of leftover that I just want to cover off finally is the new provisions on jurisdiction in the amended CJJA, the Civil Jurisdiction and Judgements Act. We've got some new sections, 15A to 15E, inserted by these amendment regulations, possibly of most relevance for the present audience. The new section 15B says that a consumer can sue their defendant, the other party to their consumer contract, in the courts for the place where the consumer is domiciled, regardless of the domicile of the other party to the consumer contract. So we've got a kind of saving bit of Brussels recast for consumer contracts. 15E of the Act provides, as it effectively pulls the same rules from the Brussels recast as we're all familiar with. It pulls those rules relating to a business needing to direct its activities to the UK in order to be caught by the new section 15B. We talked a little bit about rule 6.33 of the CPR before, and thankfully this rule has been specifically amended and clearly amended. So we're not trying to, work out by a roundabout way what it's trying to say. It's been specifically amended to say that service in these new consumer contract claims will not require the permission of the court. So you can serve out in one of these new consumer contract cases without permission of the court. I think that now covers all of my canter through the relevant bits. I'm sorry if it's gone on a little long and it's gone at a bit of a pace, but we did pause in the middle and there was quite a lot to cover. So I do apologize, Sarah, I've rather eaten into your time a bit.
Absolutely not. I just have perfectly straightforward stuff to deal with. You need to deal with sort of how does this regulation relate to that piece of statute, relate to this piece of Euro law. Okay, before we move on to where are we now in relation to claims which are going to be issued going forward, which is effectively common law rules, and where do we think we're going with this? Does anyone have any further questions in relation to issue, service, jurisdiction, enforcement in relation to pre-31st of December claims? Because now's the time to ask them, because we're going to move on now to claims issued thereafter and stuff arising thereafter. We've had a question about Gibraltar, Tom, to which I said, I think Gibraltar comes within rest of the world rules in relation to service and jurisdiction from a vague recollection I have about doing something Gibraltarian some time ago, because they're in a slightly odd position as regards Europe because of the Spanish position on Gibraltar sort of not really existing. I don't know if you've got any insight into that, possibly not.
I don't have any specific insight into Gibraltar other than remembering vividly how much of a headache it was in 2018. Yeah,
I get that. Okay, in that case, on to the common law rules. This is what's going to happen in future. So if you're not looking at a consumer contract, so if you're not looking, for example, clinical negligence, you would hope to be able to bring within a consumer contract type context, because that's the kind of thing where you've got treatment, let's say cosmetic surgery done by a foreign surgeon, where you've got a contractual background, consumer contract background or accommodation, something like that. Again, as Tom says, it's got to be directed, the activity's got to be directed within the jurisdiction. But outside of that, which is just a small saving for that, things like RTAs occurring, foreign RTAs, occurring either in Europe or in the UK in relation to foreign insurers that we were talking about previously in relation to the regulations, these are going to come under the common law rules. And this is one of those situations where being very ancient like me is a good thing, because we've seen a number of these common law rules. And actually, we were all very anxious in the run-up to Brexit Day, because we're all very anxious to get claims issued and dealt with prior to 31st of December, because after that, it looks as if you fall off a cliff because we're no longer in the EU. It's not as bad as all that. It is, in fact, possible to bring claims even without the benefits of the Euro regs structure. But the one thing I would say about it is that it is less certain. So the one great advantage of Recast Brussels was that it had total certainty. So you knew where you were. And various case law supported that you either came within Recast Brussels or you didn't come within Recast Brussels. In relation to the common law, as always, and as those people from civil law jurisdictions never cease reminding me, you know, our legal system is a patchwork. And so it's much less predictable than the Euro legal system. So we're under the common law in relation to jurisdiction, so which means that you've got two things you need to do. First of all, you've got to bring yourself within a gateway, and then you've got to show that the English jurisdiction is the most appropriate jurisdiction within which to hear the claim. So in relation to tortious claims, the tort gateways that are most relevant for us are going to be that damage has been or will be sustained within the jurisdiction. Now, you'll remember that Brownlee and Four Seasons is dealing with this very question in relation to the old CPR. It's been amended since Brownlee was applicable. But indirect damage so far under Brownlee counts as bringing you within the gateway, which means that if you go abroad and you have an RTA in France, damage has been sustained in France, but when you come back and you require care, treatment, you suffer from the effects of your injuries within this jurisdiction, that's good enough to get you through the gateway. So a foreign road traffic accident or similar is going to bring you within the tortious gateway unless you suffer no damage within this jurisdiction. Your problem in that one is going to be whether or not it's the most convenient forum. So in relation to torts, it's relatively easy to bring yourself within the gateway if you've suffered any loss within this jurisdiction. In relation to contracts, it's more mechanistic, but it's still relatively easy to bring yourself within the gateway. The contract's either formed within the jurisdiction, governed by English law, or contains an English jurisdiction clause. So again, if you can bring yourself within any of those gateways, then you move on to the next consideration, which is forum conveniens. In relation to anchor defendants, this is the kind of thing that we've seen with Recast Brussels as well, where you bring in one defendant over whom the courts have jurisdiction. You can then bring in any number of other defendants because they're necessary or proper parties to the claim. We've had quite a lot of case law lately in the last year or so, which suggests that the anchor defendant alone gateway is unlikely to be as determinative as it was under Recast Brussels. So there have been a number of cases in the last year or so where just bringing someone in because they were anchored by other defendants was not enough. Partly because the bringing in the one over whom the court has jurisdiction can't be an abuse, and we know that now, and secondly because of forum conveniens consideration. So this is the second part of the consideration, where even if you can bring yourself within one of these gateways, you've still got to satisfy the court, and it's for the claimant to satisfy the court that England and Wales is the proper forum in which to bring the claim. And so you've got to show that not only have you brought in one English defendant, for example, you've brought in 18 French defendants, you've got to show that it's the proper forum within which to do that. So one anchor defendant against whom there's a very weak case is not going to anchor 18 defendants against whom there's a very strong case, but they're outside the jurisdiction and the accident happened outside the jurisdiction. So although as a matter of formality, it's going to be possible to bring a claim against a foreign insurer in relation to a foreign RTA because of the damage gateway, the tort damage gateway, you may have more difficulties persuading the court that it's a good idea to do that, because it's not the convenient forum, because the accident didn't happen here. A large amount of the, for example, medical treatment may not have happened here. The witnesses may all be in the foreign forum, and all of those are going to be factors which are taken into account. The case to look at in relation to this is Harding and Whelans, which is pretty ancient now, as I say, but it does list a number of factors. Which factors the court are going to take into consideration is pretty well known, because they've already been dealing with these matters under rest of world cases. So there's a real effective body of case law dealing with this concept of forum conveniens, but it is an English concept. You've got to forget everything you think you know about recast Brussels and look at just the common law rules and ask yourself whether or not it looks like it's the appropriate forum. We're going to see a much bigger body of case law, I'm sure, going forward in relation to these cases. It's then also got to be possible to serve the proposed defendant either outside or within the jurisdiction. We're going to see a lot more jurisdictional challenges, I think, in relation to whether or not service has been properly effected. I've actually just done a jurisdictional challenge, which was a case in relation to a Dubai-based defendant, and we were serving on a place of business within, or what we said was the place of business within the jurisdiction. Court found that it wasn't a place of business of that Dubai-based entity because it was a place of business of an agent of that entity. We're going to see a lot more challenges along those lines, I think. We got home on alternative grounds, of course, but it's going to be a case of looking at CPR Part 6 and looking at how to serve on the rest of the world and trying to bring yourself within one of those provisions. So it's still CPR Part 6, really important, much more important now than what used to be quite a mechanistic approach in relation to jurisdiction. So these challenges are going to get more and more prevalent, I think, and we're going to get a body of case law, as I say, that tells us much more about forum conveniens, much more about possibilities on service. You've also got to bear in mind that your claimant needs to be English domiciled in order to make these claims work. And that's something that is also likely to be challenged much more in future, and it's likely to be that defendants are going to be asking for proof of that as a matter of course now, which wasn't happening before. So in relation to jurisdiction, it's going to be much less predictable, I think. In relation to recognition and enforcement, again, that's going to get much more difficult, and I think it's going to get much more piecemeal. So we've had this UK-Norway agreement, which has been knocking around since 1961, updated last year in anticipation of Brexit, and there will be other agreements, international agreements as regards recognition and enforcement of judgments. Of course, there won't be a lot of them in relation to European nations because we didn't need them because we have Brussels and then recast Brussels, but there will be further agreements. And this is where Tom and I start to part company in relation to our views on what's going to happen in the future, because Tom is a pessimist and I am an optimist, as everyone knows. And I think we're going to produce a lot more of these agreements going forward. We've got lots of rest of world agreements. So, for example, there's an agreement with Dubai. I think there's an agreement with Lebanon. There's other various agreements. Singapore, I think we have an agreement with. And all it is just a question of taking the template and rolling it out to other nations. But you will need to take advice on enforcement from foreign agents, because before you embark on one of these cases, you need to know that if you get an English judgment, it's going to be enforceable. And that is a matter of foreign law in the jurisdiction concerned. So although Tom and I can say to you, well, look, there's a UK-Norway agreement, so it ought to be enforceable, it is worth checking with a Norwegian lawyer that actually we're right about that, and that the Norwegians, as a matter of their domestic law, are going to accept our judgments in the way that we think they ought to, pursuant to the agreement. So it's going to become necessary to take a lot more advice in relation to enforcement from foreign lawyers. So this is going to be an area where I think somebody asked a question earlier as to whether or not it's a good idea to issue now or wait 6 months if you can until we get these agreements in place. Now, Tom, I would imagine, would say, haha, it's going to be a lot longer than 6 months. I think the answer to that is that we will see how quickly these agreements come in. We've got Norway already. There's no reason why we can't reach agreements with some of the more reasonable European nations. and get these agreements rolled out so that we can get enforcement up and running. But it is not worth issuing in relation to, let's say, a French case if you don't know that you can enforce. So it's better to hold back on issuing now. Having said everybody must issue prior to the 31st of December, I'm now saying nobody must issue at all until I say so. But you've got to take advice on foreign law to see whether or not any judgment you may get might be enforceable. There are, of course, the HAGUE Judgements Convention, very recent, which replicates the New York regime for enforcement. It will cover personal injury, which is a distinction from some of the other Hague suite of conventions, but we haven't signed up to it yet. You'll see that Tom devised this slide and wrote, will likely be years down the line. I actually subscribe to that, I think. I think the Hague Judgements Convention is some way off. Even as optimistic as I am. So I don't think we can look forward to that for some time to come. People tend to, I mean, civil servants, actually, let's be honest who it is who's delaying matters. Civil servants tend to wait for things to marinate for a decade or two before they accede to them. So I think it's a way off. And actually, I think the Legano Convention, I see that as the great saviour. I know that Tom's a little bit more, I see him shaking his head. I know that Tom's a bit more reticent about this as to whether or not we're going to join Legano anytime soon. It is supported by the EFTA states. So it's supported by the Legano states, but the other party to the Legano Convention is the EU, which is blocking us getting into the Legano Convention. I know that a lot of work is being done by members of APA. I know particularly Chris Deacon is doing a huge amount of work trying to push the Legano Convention forward. Legano is the recast Brussels, or is the old Brussels rather, regime. And that's why the UK is quite keen to join it, because it just almost seamlessly, if we could have joined it on the 1st of January, would then transpose the old Brussels regime into UK law. But accession is a 4-stage process. We have asked to accede to Legano, so that's fine. We then need unanimous approval by the contracting parties. As I say, we got it from the EFTA parties, but we don't yet have it from the EU, and that's what's blocking us. We're stuck at the stage 2 of the process. Once all the contracting parties have agreed, so when the EU decides to let us in, if it decides to let us in, we then deposit the instrument of accession, and there is then a 3-month objection period. So we know that Legano can't come into force until 3 months after we deposit the instrument of accession, and that can't happen until we get the EU's approval for us to join Legano. So we know that Legano is not going to happen any time within the next 3 months at least. Tom would have you believe that it won't come within any time within the next few years. I actually think that we may manage to crowbar the EU into approving our accession, because there is then the ability for a contracting state that previously approved accession to object at that stage, which would then mean that Legano would come into force between us and EFTA and any states that don't object, but doesn't enter into force between the UK and that state. So that is it seems to me that that is a reasonable way of moving forward with these things. But Tom's been talking about the EU's objection to cherry picking, and I know that that is the EU's problem with us joining Legano, that they say, well, you can't have Legano and none of the other aspects of the EFTA procedure. What happens if we do get Legano, as I think we're likely to? The provisions are similar to those of recast Brussels. They're not identical. They're more similar to previous Brussels, so unrecast Brussels. And the big differences are that our courts would not be bound by the CJEU, which is why it's attractive to us, but merely take due account of its decisions. There's no mechanism by which we can be penalised for failure to comply with the Legano Convention. Again, that's another reason why Legano is more attractive to the UK government than recast Brussels was. But the difficulty with it is that exclusive jurisdiction clauses don't carry the same weight. So the Italian torpedo, namely the ability for a potential defendant to torpedo a claim by bringing preemptive proceedings seeking a negative declaration, that is going to be much more live if we enter Legano, because that's possible in a way that it wasn't under recast Brussels. So even if we do enter into Legano, which I think is best case, there are still issues with it, because the Italian torpedo was a problem, and indeed one of the problems that recast Brussels is actually designed to address. So Legano is not it's not the magic bullet, and even if it were a magic bullet, Tom would say to you that it's a magic bullet approaching the UK at very, very low speed. But only time will tell as regards how that sorts itself out. And it's very difficult to predict timings in relation to that. In the meantime, the only thing I think we can do is to try and deal with the pre-Brexit matters in the way that we've outlined, in the way that Tom outlined in answer to the questions that you've given. Keep calm and carry on. Believe, because I think we have to believe, that there will be some agreements in relation to recognition and enforcement, and that there will be either Legano or the HAGUE Conventions will come online at some future point. But I've got to say, I think in relation certainly to the HAGUE one, that is some years off. In relation to Legano, either months or years off. I mean, we are not looking at anything changing significantly for some significant period to come. We're then left to fall back on the common law rules, which, as I say, are not as predictable. So my advice to the person who asked a really good question about service, or rather issue now, is to wait as long as you can wait reasonably and see how things untangle themselves. That is likely to take some considerable time, I think. And actually, lawyers, of course, barristers like Tom and me, always want to be the people who are involved in test cases. We always want to be stretching the law and testing it and seeing what it's going to be, and we like to be involved in those cases. Clients seem strangely reticent about being involved in those risky cases. You know, I venture to think that possibly Lady Brownlee is regretting ever getting involved in the English legal system, because she's still a decade on, embroiled in the Supreme Court decision in relation to whether or not they've even got jurisdiction before she even moves on. So I think, you know, we want to be involved in these cases. We're very excited about the unpredictability of the law, but clients, not so much so. So that's a very quick canter through where I think we are and where I think we're going. Can see that we've got some questions. Let me just have a quick look. Tom, feel free to leap in. And what do I got? What if you only receive your treatment overseas and no other treatment is required and returned to the UK? This is in relation to the cosmetic surgery, clinical negligence type cases. If you only receive your treatment overseas, but you've either entered into your contract in the UK or your surgeon is directing activities to the UK. So let's say you've got an English website which is in English and you pay in sterling, and it's marketed to the English markets, then they are directing their activities to the UK. And so jurisdictionally you should be okay, I think. In relation to your applicable law, though, that's going to be wherever the negligent act took place. So it's going to be Romania or Czechoslovakia, or wherever it may be. So the applicable, you've got to bear in mind that jurisdiction and applicable law are two conceptually different concepts. So I think your applicable law is going to be foreign, but the English courts are going to have jurisdiction. But bear in mind that there may be no recognition and enforcement of judgments. So where you've got a foreign provider, are you going to be able to enforce any judgment you may get against them? So that's the query. The answer to that may well be yes, because they are directing their activities to the UK. They may have UK insurers standing behind them, but my experience of a lot of these foreign-based, particularly cosmetic surgery providers, is that either there isn't insurance or it's not adequate, for example. What else do we have? Reference to the HAGUE Convention gets you muddled. Okay. If serving
that was my fault. I think that was one for me. It was the
okay.
Talking about two different HAGUE conventions.
Right. Of course.
Nicholas was talking about the earlier convention on service, whereas when I was saying that the 2005 HAGUE Convention on choice of courts and recognition and enforcement probably wouldn't be of much use to the present audience. It will obviously be of huge relevance and importance to lots of other people, but I'm assuming that we're mostly here talking about torts and consumer contracts and personal injury cases with the present audience. And for that audience, the 2005 convention is not going to get you very far, because they are specifically those three things: personal injury, consumer contracts, torts, obviously. are not within the scope of that convention. But I wasn't denigrating any other of the rather large suite. There are lots of, I think there are scores of Hague conventions dealing with all sorts of other bits of civil judicial cooperation, and I wasn't putting any of those down at all.
You're going to cause an international incident, Tom.
Yeah.
Another question. I'm sorry, I know that we've overrun a bit, but it's actually quite difficult to fit everything that has happened and may or may not happen into the course of an hour. But any other questions in relation to that, either for me or for Tom? As I say, Tom has a slightly different insight into it because he's actually had to deal with these issues in the run-up to Brexit. You're very welcome, Nick. The slides will be available, I should say, in the usual way after the webinar, and it will be a recording of it, suitably topped and tailed by Emma to get rid of Tom's and my gossip at the beginning, will be on our YouTube channel as always. Let me just check if we've got any other questions. Otherwise, we'll sign off. Oh, Emma will kill me if I don't tell you this. Next week, no, week after next. It's not next week. Fundamental dishonesty and clinical negligence claims, which is on the 11th of February at noon. Oh, I've got a thing on the chat that will be Emma telling me off for putting next week, I should think. I've had another question on the chat. Let's have a look.
I think it's about your cup of tea, Sarah.
About my cup of tea?
Yeah.
Blah, 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 blah. Might we consider running a session on cross-border family cases post-Brexit? Family cases is not really an area that we get involved with because it's a very specific area, and actually that is yet another of the Hague Convention areas. And although the family cases on forum conveniens are relevant in this context that we're talking about, there's actually a whole slew of case law which is its own internal and complete case law. I could try and do you a cross-border family forum conveniens webinar or article, but I wouldn't be able to give you the practical stuff that Tom has given you in relation to service and so on and so forth. Because that's, as he says, one of those Hague Convention cases, or one of those Hague Convention things that we don't really get involved with. I'm afraid that's not really our sphere. We're more civil and commercial, personal injury and so on. So sorry, Lorna, but that's not really our field. I
think Lorna's also asked you a question about the policy choice for keeping consumer contracts in, as it were, even though the rest of Brussels has gone. I don't have any particular insight into that, but what I would say is that it's almost certainly a kind of trade-off that the UK government has decided to make, in the knowledge that it won't necessarily be reciprocated by the EU across the channel. So they've said to themselves, okay, look, we're not going to get a reciprocal agreement on jurisdiction with the EU. So our starting point is therefore we're not going to offer anything. But what is perhaps the best policy choice for us to make, given that the EU are not going to reciprocate or might not reciprocate, who knows? And I think they've probably decided that consumers, you know, the little guy, the person who needs protection the most, should have a little bit of saving protection that allows them to keep bringing their cases in the English courts. That's my guess, that it's the kind of a unilateral decision by the UK, knowing that the EU aren't necessarily going to reciprocate, but in order to protect the more weak and the more vulnerable litigators.
I think it was just a sop they threw to Chris Deacon to get him to stop going on about the Legano Convention, possibly. But that, again, another policy decision. Okay, well, if there are no other questions, it's been really lovely to see you and chat to you all, and particularly lovely to see you in actual real life, Tom. And
well, no, only virtual real life. So not well, even.
This is as close to real life as I get, Tom, rather than talking on emails and stuff.
True.
So I hope to see you not next week, but the week after. And yeah, the slides will be available, so look after those coming to you from Emma. And otherwise, we'll be on YouTube. Thanks, guys.
Thank you.